Okay. So welcome back. So we just finished discussion on international arrangements, conventional applications, then multiple priorities, and what happens to those application files and special provisions. Now we are going to discuss some miscellaneous sections from 140 to 163. Okay, so among all these sections, only the section 140 is slightly tricky. Otherwise, all others are very straightforward. Okay. So 140 is avoidance of certain restrictive condition. Okay. So whenever we are, our client is going to have any kind of clause in their any kind of license agreement, they need to avoid these kind of conditions. Okay. So what I would suggest that please read the sections from here. I'm going to tell you in very simple form. So in any contract, sale or lease of patent article or patented process, okay, or license to manufacture or use of patent article, okay. So anytime if your client comes to you and says that I'm going to have a license to manufacture and please draft agreement, okay. So these things should not be there, or in a license to work any patented process. So anything patented is should not be like this. A, to require purchaser to acquire from vendor or to prohibit use a product other than patented product or patented process. For example, you have patent on the car, okay, but you do not have patent on what kind of color a car may have. Okay, I'm taking very simple examples. You have patent for car, but you don't have patent for what kind of color or coating can be there on the car. So car can be red, car can be black, or car can be white, or car can be any other colors. So you don't have patent on those. You cannot say that because you are purchasing car from me, you cannot have a red paint on the car. You can only have black paint on the car. So because that is not patented, you cannot ask them any condition on those. This is the meaning. To require purchaser means purchaser has to do this. You cannot put a claim that a purchaser of the patent or the patented process or the license agreement, you require purchaser means you cannot force purchaser to acquire from vendor or to prohibit. You cannot ask him to acquire. You cannot say that because you are purchasing this patented product, you have to purchase this also. Means I have a patent for let me take another example. I say that I have a patent for pencil, but because you are purchasing pencil from me, you have to purchase the eraser also from me. Acquire from vendor from me only. Or to prohibit, you cannot stop also. I cannot say that no, you cannot use the rubber. Something like this. That means you can frame sentences regarding the patented process, but something which is not patented, you cannot force him for that. To restrict in any manner, use article other than a patented article which is not supplied by the vendor. To restrict in any manner, you cannot restrict, okay, to use articles other than a patented article. So if my car requires tires, so I cannot say that no, you can purchase the car body from me, but you cannot purchase tire which is not supplied by me. You have to purchase tire only which is supplied by me only. Okay, so those kind of restrictions you cannot force there. To prohibit use of process other than patented process. So, for example, your system requires step 1, step 2, step 3. You cannot say that no, you cannot use a step 3. Okay, although step 3 is not your patented process, but you cannot force him to prohibit it because to provide exclusive grant back, you cannot say that because I am granting you exclusive right, now everything is granted to you. You cannot ask him or write a clause that after 4 years you grant back to me. Prevention to challenge validity of patent. Okay, you cannot say that if I grant you patent, you cannot go to court and invalidate my patent. For example, if I have patent and I gave a license to my friend Rajat to operate on this patent, but I am charging him 1 lakh rupees per month for the license. Now Rajat finds it very difficult to pay 1 lakh every month for the patent process because he's not earning that much. He may be earning 50,000 rupees, but again he has to give 1 lakh rupees to me. So he may bear the loss for 1 or 2 months, but if it is perpetual loss, then what he may do, he may go to court and prove that my patent is not valid. Means he can file a revocation suit. If it is within 12 months, he can go for post-grant oppositions and his patent is revoked, or he can go after 12 months, he can go under section 64 and revoke the patent. And once the patent is revoked, then the license is not valid, and then I don't have to pay 1 lakh rupees to me. Okay, so therefore, to avoid those things, you cannot ask him that I will grant you license, but you promise me that you will not challenge the validity of patent. Okay, or coercive package licensing, or you cannot force him to bundle the licenses together with something else. Okay, so any such condition shall be void. So if any such condition is there, so that will not be considered. So please read these lines in 140. Only that this part is little tricky one, but in simple language, if you want to understand, it simply means that if I have patent and I want to give license or use anything, why should I restrict him to not use something else? Okay, I cannot restrict him that you have to purchase this from me only, you have to use this only. No, what patent says that if I have patent and the patent is active, then I have the exclusive right to prohibit others from making, using, selling, importing. Okay. So those I can do anything for the patented process or patent article, but which is not patented, I cannot force it. So if that comes in picture, then that is why that is not applicable. So when we're drafting the application, this should be there. So this question was there, I think in some other paper where true false kind of thing was there, and you had to choose the true and false. The condition mentioned above in clause A, B, and C, okay, should not be there even if the agreement containing them were made separately before or after the contract relating to sale of the patent article process. Okay, so suppose we are not talking about the patent article, but before the patent article, I had an agreement with someone that you have to take the tires from me, you have to take the car coating from me only. And now when the I get the patent for the car body, then I cannot say that because this agreement of taking tire and this only this car is before the patent article, and now this get combined together. Now the other person who is taking license for the car body, he will have to take the car body from me, and again he is forced to take tires from me, he is forced to take the coating from me. So this is not allowed. Okay, the condition mentioned above in clause A, B, C should not be there even if the agreement containing them were made separately before or after the contract relating to sale of the patent article or process. Pretty simple. You cannot do like this because then you are killing the competition. You are not allowing other to enter the competition. In the proceedings against any person for the infringement, okay. So if infringement happens by a person, it shall be a defense to prove that at the time of infringement there was in force a contract to patent and containing condition which is unlawful. Okay, so for example, you force something that you have to use this or not use this, and then because you're using this, infringement happens. Then if you can say that I am using it because of this contract which is unlawful, okay, then that is a defense for me. Means I can be safeguarded from the infringement suits. this subsection shall not apply if the plaintiff is not a party to the contract and proves that to satisfaction that the restrictive clause were inserted without his knowledge. Means it cannot be used as defense. Okay, what it means is that if plaintiff is not a party to the contract. Okay, means plaintiff means one who is complaining about the infringement. He is not party. Means he is not complaining about this, or he says that that proves to satisfaction that restrictive clause were inserted without his knowledge. Okay, so this something is put in there. Okay, so something is included here. So what it means that if infringement is there, so I am using this substance because of this existence of the agreement. Because agreement is there, I am forced to use this, and this agreement is unlawful according to section 140 ABC. Okay, this is unlawful, and the person who forced me to use it, okay, forced me to use it, is having the patent. Okay, having the patent. This substance shall not apply if the plaintiff is not party to the contract. Okay, so if the plaintiff means person who has formed the agreement, he's not the party to the contract. Okay, so please read this section clearly in simple language, meaning that it is talking about the safeguarding the interest of both the persons. So I am the user and you are the supplier of the patent or the agreement. So it is trying to safeguard both interest. And number four, it says a contract can prohibit a person from selling goods other than those of particular person. Okay, so section 144 says nothing in this section shall, okay, nothing in this section shall prohibit, affect a condition in a contract by which a person is prohibited from selling goods other than those of a particular person. Okay, meaning that I have a contract on a patent, but I am also selling, I have a contract on a patent on car, but I am also selling bike. Okay, so this section is not talking about those. Okay, nothing in this section shall affect a condition in a contract by which a person is prohibited from selling goods other than those of particular person. Okay, so sometimes it happens that you take what is said franchise, you take something like this, and you and then according to the franchisee, okay, according to that franchises, you cannot sell anything other than that franchisee cases. So that is not counted here in this section. This section only talks about the patented articles only. Okay, and B says validate a contract which, but for this section, would be invalid. Okay, one cannot validate a contract which is invalid as per these sections. Okay, so nothing in this section shall. So again, you have to read again. Nothing in this section shall validate a contract which, but for this section, would be invalid. So if a contract is invalid, you cannot bring it here and make it valid here. And number 3 says, affect a condition in a contract for lease of or license to use a patented article by which the lessor or licensor reserves to himself or his nominees the right to supply such new parts of the patented article as may be required to put or keep it in repair. Okay, contract can reserve the right of licensor to supply such new parts of patented article as may be required or to put or keep it in repair. For example, I have a patent on a complete car, and then I can have the contract that that you have to take the parts from me because those parts are required, and these are under patented article only. New parts of patented articles. Okay, so because patent office is trying to safeguard the interest of person who has patented the article. Okay, patented the article, and therefore if he puts in the contract the clause that for the maintenance, you have to take the parts from me only, and these are patented parts, then that is allowed. What is not allowed means, what is not allowed? You cannot force him to purchase something which is not patented. Okay, you cannot force, and you cannot say because you are purchasing patented article from me, you have to purchase this article also from me only. Okay, or you cannot say that because you are purchasing this article from me, you cannot purchase this article from some other vendors. Okay, so in very simple language to understand section 140, it says, say for example, that I have a patent for pen. Okay, another company ABC has a patent for pencil. So I say that I will allow you to use this pen only if you don't use the pencil of that company. Why should I force that you cannot use pencil of that company? Okay, so that kind of agreement is not allowed as per this section 140. Very simple. I can prohibit anyone from using or selling or importing anything which I have patented. Okay, but I cannot force him that you cannot use or sell or do anything of other person. Okay, which is not my patent. You cannot use there. You cannot purchase those kind of conditions null and void. But what is good part is here that if I want to safeguard myself in future, so I have a long tenure of 20 years, so I can say that you have to purchase the parts from me only, then only it will be valid. So that clause I can have. Any doubt here? Because it looks to be complicated. So do you have any doubt in section 140? No doubts? Very simple one. Section 140 says that I can prohibit anyone from using, selling, or for the patent article only, but something which is not patent, which is not protected by my patent, I cannot force him to use or not use those things, either from me or from others. In very simple language. And if but what I can do that in future also, you have to purchase these parts from me only. You can purchase for this part from me only. That I can say that you have to purchase from me only. Those kind of clause can be there, so that is allowed. Okay. Okay. If there is no question, then we will move forward. Section 141. Determination of certain contracts. Any contract of a patent article or process can be determined by the purchaser by giving 3 months on notice to other party. Okay, you can give 3 months notice and it can be finished. Okay, or if the patent cease to enforce. Okay, so two conditions. One condition is this is D. So if there is any contract for the patent article, so how much notice is required? 3 months notice to other party, and you can terminate the contract. So just like if I take a house, then I need to give my owner 1 month notice period before vacating the house. Similarly, if we have a contract on the patent article, we just need to give 3 months of notice to the other party and to finish it. Or if the patent ceased to enforce, means patent has expired, he has not paid the fees, or it has been revoked, whatever the case may be, in either ways, if the patent is not enforced, then that contract is not enforced. The provision of this section is without prejudice to any rights of determining a contract apart from this section. Okay, so they also safeguard that they are not harm other rights. Section 142 regarding fees that we have discussed many times regarding fees. So fee need to be paid. Okay, in the process of grant of patent, controller will not act until the required fee is paid. So this is important. So controller will not act. So if you have filled the form, but if you have not paid the fees, then that form is not means there is no use of that form field. You may have to fill again. If the fee is not paid during document submission, document is considered not filed. So this is important. So many times when we file application, then we need to be sure that the fees is paid. So only when the fee is paid, that day they count as the submission of the document. So if I submit the document online on a Friday, but I paid the fee on Monday, then the Monday that date will be counted as the filing of the document date. Where a principal patent is granted later than 2 years from the date of filing application, the fee which has become due in the meantime may be paid within a term of 3 months from the date of recording a patent register or within extended period not later than 9 months from the date of recording. Refer to section 53 and rule 80. Okay. So what it says, renewal fee to be paid at expiration of second year. Okay. So after the second year, means when the second year when complete, you need to pay the fee from the date of patent. The date of patent, you need to pay the fee. Section 45, filing date of patent application. Extension of date for the fee payment is not more than 6 months. Okay. So what you need to do, you need to fill form 4 and fee 480 or 2400, as the case will be, 480 for the natural and 2400 for the corporate. Okay. 143, restriction upon publication of a specification. So publication of any specification before 80 months under section 11A1 or section 11A3 or section 43 grant a patent will be with the consent from the applicant. Okay. So applicant consent is required for the publication of any specification. Okay. Section 144, reports of examiners to be confidential. Reports of examiner to the controller under section 14 is not open to public inspection. Controller cannot publish it. Okay. It is not produced in any legal proceedings. It can be done if court asks for it. Okay. So that is only communicated to the applicant. That is not published. Means you will not file any report where it says these were the questions raised by examiners and these were the reply from this. So they are not published. Section 145, publication of official journals. It simply says official journals are published periodically. So sometimes this section 145 is asked. Section 143 can be asked, meaning in a true and false scenario, because it says consent will be published with consent from applicant. So it can say that publication, any application before 80 months can happen without consent of applicant. Okay. So this is not true. Okay. Consent has to be taken. Why it is talking about consent of applicant? Can anyone tell? So if you read section 11A1 or section 11A3, then you can tell me answer. Please refer to section 11A1 and A3 and tell me why this consent for applicant is written here. I am also opening it. So please read from the book, section 11A1. A1, and then let me know why it says. Or 11A3. Yes. Can you tell why they're talking about the consent from applicant?
Sir, it is for like section 143 says that restriction upon publication of specification. So according to 11A1, any application is published only after 18 months, which is mentioned here that save as otherwise provided, no application for patent shall ordinarily be open to public for such period, and that period is 18 months as may be prescribed.
Correct.
And according to section 11A3, there are certain conditions in which the application cannot be published. So in case of secrecy direction abandoned according to subsection 1 of section 9, and if it has been withdrawn 3 months prior to period specified under subsection 1.
Correct. So those will not be published, and they are not open to public. So section 11A says, shall ordinarily be no application for patent shall ordinarily be open to public. So therefore, it is just reinforcing those same thing. So because they are not open public, and consent means, what is the meaning of consent? Consent means, what do you mean consent? Consent means one has to, applicant has to apply for the publication, right? Publication of the application. Then only it get published. Okay. Section 146, power of control to call for information from patentees. So this is important, and we read about it that there is a heavy fine. So controller can in writing ask to furnish information about commercial working of the patent. Such notice needs to be furnished within 2 months. So if you get a notice that controller has asked, so meaning that we know that they have to furnish commercial working of the patent information, and if controller asks for it, then 2 months time period is there, and if you do not do it, then section 122. So anyone remembers what is the section 122? How much fine it is? How much fine they have to pay? 122.
1 lakh. 1 lakh.
1 lakh. Section 122. Refusal or failure to supply information. What it says? May extend to 10 lakhs.
10 lakhs, sorry.
Huh?
Yes.
So it's not 1 lakh, it is 10 lakh rupees. Okay. So if you don't supply this information within 2 months, then you may have to 10 lakh rupees. So that is a very huge amount. Every patent needs to submit detail about working the patent on commercial basis. Form 27, there is no fee. You have to do it again once in every financial year within the expiry of 6 months from the expiry of such financial year. Rule 131. So once in every financial year you have to submit it, and then you also have a 6-month time period. Once in every financial year within expiry of 6 months from the expiry of such financial years. So after the financial year ends, so within 6 months you have to submit it in form 27. So if you want to have information regarding how much it is being worth, how much benefit they are getting from a patent of any company or for any patent, you can look in form 27. So if you go to patent office website, and from there you can download the form 27 for each patent, and then you can see some details, how much money they are, how much benefit they are doing, what are things that they are doing, that you can always get it. Control publish details and information in form 27. 147, evidence of entries, documents, etc.
Prem, in 146, I just have one query.
Yes.
Can you go back? Can you go back?
Yes.
So what is the point 1 then? Because anyway, you have to fill this information about the patent is working or not every year, every financial year. Then when the section 146(1) it will come?
Yeah. So controller may ask for it. Okay. So even if you have filed it, but then also they may ask for it. Okay. And suppose if you have not filed it, then also they may ask for it. Okay. So it simply means that we have to fill it because sometimes for the big corporates, this 2 months time may be less time if they are asked suddenly that you furnish the information about this specific patent. Because we know this in companies, it is not like that one patent is generating the revenue. It is always a bundle of patent that generates the entire revenue. So you cannot say that this one patent is generating the entire revenue of the company. So to segregate and define, so they have to fill the form. And if you have not submitted to Form 27 and controller suddenly asks for it, then you have to do it within 2 months. Otherwise, you get 6 month time, right? So once in a financial year, but you see after within the 6 months of the expired financial year. So you have 6 month time, then again 1 year time to understand and fill the details. But if you don't do it, controller may ask it, and if you fail to submit that information within, then shall be punishable with fine, which may extend up to 10 lakhs. So it does not say that 10 lakhs rupees, right? So for example, I am an individual person and I did fill the form 27. My entire budget is not 10 lakh. So patent office cannot say that you have to pay 10 lakh rupees. You take personal loan and then pay the fine. So it says that may extend to 10 lakhs. So always please remember these wordings. May extend to 10 lakhs rupees. So in the simple language, you can say the fine is 10 lakhs, but in exam, you will always get this option. 10 lakhs may extend to 10 lakhs, okay? Or may extend to more than 10 lakhs. So this option will be there, and as always a tendency to get confused. Is it 10 lakhs, right? Or may extend 10 lakhs, right? Or may extend more than 10 lakhs, which is right. So it is not more than 10 lakhs, it says, which may extend to 10 lakhs, meaning they may find us 100 rupees also, or 1000 rupees also, or 1 lakh, 2 lakh, 3 lakhs, 4 lakhs, 10 lakhs. Up to 10 lakhs, they can find, patent office can find. So depending on the invention and how much they think, the capability of the company, they can find up to 10 lakhs, which may extend 10 lakhs. Okay. So section 147, evidence of entries and documents, etc. So what it says that prima facie evidence of entries and register is certificate signed by controller. So in any kind of dispute in a high court or a district court or for any other purposes, if controller signs that this is the details are there, then that is considered the primary evidence. These documents shall be admitted as evidence in all courts. Okay, that is accepted in all the courts. So mostly it happens during the fight, during the license agreement only. Okay, license agreement, exclusive licenses, compulsory licenses, those kinds of things are there. And then if you have some agreement with the patent, you have sold the patent. So those kind of things are there, and then which is the evidence what has been entered in the register. Therefore, entry in the register is the must. You have to enter a register, and because whatever has been entered, that is counted as evidence. And then if something which entered the register is not correct, you can rectify it. Now your memory test, can anyone tell which is the section which talks about that all the everything has to register in the patent, and if not, and if there is any wrong register, you can always protest. What are those sections?
Section
Quickly.
67.
60.
Register of patents and particulars to be entered there.
Correct. Register. So this register of patent section, correct. You're correct. That everything that is mentioned here. Again, section 68. Assignments not valid unless in writing and duly executed. Okay. And registration of assignment and transmission. So all these sections are there. Okay. And then we have read how form 16 is required, and then rule 91, everything that we have discussed in this matter. Controller or any other officer will not be forced to produce a register unless in a special order by court, but the certified copies can be produced. Okay. So certified copies are produced. So certified by court that can produce, but exact register will mean, I think these sections applies like earlier there could have been like only registers, right? Physical registers like copies. So they can take the register itself and produce the code. But nowadays it is everything online. So I don't know how to interpret this. So controller or any other person will not be forced to produce register. So this register meaning This is the Patent Act 1970. So for long time, we had all the entries in the register, everything was mentioned in register. And if there are court case, they can just sign on the paper that these are the entries, and then the stamp and seal, and then, and that is evidence. But in some circumstances, they have to carry the entire register and the present in the court. But now, because everything is online, everything is done online, and details are there, so I don't think the physical register has to be bought in there, but we'll see. Declaration by infant and lunatic. Okay, so if someone is lunatic, means out of mind, or infant, small children. So I have seen recently some news articles where it states that a child below age of 18 years, they have filed a patent. So this is called declaration by infant, will come in that cases. For case of infant and lunatic, the lawful guardian or as person appointed by court can perform the task. Okay, section 148. And an appointment may be made by court for the purposes of this section upon the petition of any person acting on behalf of such person. Okay, so very simple. If small children below 18 years they do it, then everything that guardian and someone appointed by court can do it. Section 149, service of notice by post. Okay, any notice, application, etc. can be filed by post. So by post also you can do. Now it is done by email, but I think most of things, even although done by email, it has to submit a post, hard copy is submitted. And 150, security for the cost. So if a person not residing in India, okay, 150, okay. So if a person not residing in India or having a business, make application for notice opposition, grant or license, such person will be required to give security for any proceedings. If it is not given such notice opposition, or application will be abandoned. Okay. If it is not given some notice opposition, or application will be abandoned. So they have to give some security. So if you want to learn the security, so there is something on in the schedule how much security they ask for. Okay, so that you can read. We have not discussed more in detail, but they need to pay some security for hearing those cases. Okay, if they are not residing in India or having a business in India, if they make application for notice of opposition or of license, then they have to pay some security deposit. Okay, so 151, transmission order of courts to controller. So order of so now we can see this appellate board, it gets striked out, it's not there. Order of High Court or appellate board on petition revocation, certificate of validity will be given to controller. Controller will make entry register. So whatever the case may be, High Court will inform the controller, and controller will make changes in the register. In suit of infringement or validity under section 106. What is section 106? What is section 106?
Power of court to grant relief.
What is relief? What is that relief?
In case of for infringement, for groundless threats for infringement.
Correct. Okay. So you should infringement or validity under 106. So 106, the judgment copy is provided to the controller. So what happens in that under 106? What happens there? What is the validity? So under section 106, if there is a groundless threat of infringement, then what happens that the defendant, he has to prove that my patent is valid and the infringement valid. Meaning, if I have a patent and my friend Rajat, maybe any name, so Rajat, he's infringing on the patent, and then I give a phone call to him and I say that I'm going to take you to court because you are infringing on a patent. Then he goes to court under section 106 and says that I want a relief because his threat are groundless. Okay, then I have to prove in the court that my patents are valid and his product or process are infringing on the patent. And then what he can do, he can say that no, his patent is not valid. It is not inventive. It is not novel, or any ground he can invalidate the patents. So in that case, what is this talking about validity? So validity or invalidity. So it don't say invalidity. So patent is valid or not valid. Any the case may be, the judgment copy is provided to the controller. Okay, this is the meaning. This applies even if appeals are preferred against decisions. Okay, so anything in favor or not favor, they are given. 153, information relating to patents. 153, a person can make a request for any information relating to patent. So what they need to do, form 30, because they know a specific form, fees 480 for nature and 24 for others. Rule 134, any details related to patent and its prosecution, a separate application is filed for each item. So if you quickly see rule 134, so what is there in 134? They have given a list. The 134 gives a list of items that can be there. Okay, so I'm just reading out here, or you may open it. 34, rule 34, as to when a complete specification following a provisional application has been filed. Okay, so you can ask the date. When was the date of provisional application? When was the date for complete specification was filed? Okay, or application for patent has been deemed to be abandoned. So all the detail you can ask, but for each request you have to pay the fees. Second request you can have, as to when the information under section 8 was filed, means information relating to foreign application. So you can ask the court controller that when this company or this company is filed regarding this information under section 8, when the application has been made under this application for publication has been made, section 11A, section 11B, as to when an application has been withdrawn under section 11B. So if suddenly application has been withdrawn, we can ask when it was withdrawn. So they have given a list of items that you can ask. Okay, so for each item you have to fill separate form, separate request form, and separate fees need to be paid, and they will give when the renewal fees are paid, when the patent was granted, as to when an application for patent has been refused, when the application has been refused, everything, all those informations are provided if you pay the fees. So this is under section 153. Section 154, loss or destruction of patent. A duplicate copy of patent may be issued by justifying its loss and making payment fee 60 under rule 132. But nowadays, because we have this electronic copy, so usually you get one copy from patent office with seals and everything there. So that's like a proud moment for anyone. But because nowadays we have this electronic system, we can save it. Earlier, it will be the case that you lost the patent, the paper are destroyed much before the way you use computer now. But in today's scenario, how it applies, we need to discuss. Section 155, reports of controller to be placed before Parliament. Okay, so controller will place report in both House of Parliament once a year. So report means, if you go to Patent Office website, you can see that Patent Office publishes a report. So what the report contains, it says how many filings are there, how many PCT applications are there, and in which categories, which company has filed more, who are the most universities. All those reports, you can have a look at this. So these reports are published, and controller places the report in Parliament. So this section 155, it forces the controller to produce a report to Parliament. Okay. So if you are asked that under because of which section, controller has to produce a report in Parliament. Okay. So this is section 155. Patent to bind government. Okay. Subject to provision of in this act, patent shall have all intents like against the effect as against government as it has against any person. Okay, so patent can bind government also. So therefore, government has to, like we have section 47 and section 99, 100, 103, those sections we have to understand. So apart from those, government is also with patents binds government also apart from those sections. Section 157, rights of government to sell or use forfeited articles. Okay, so if government has forfeited articles, so government can sell or use any articles forfeited under any law for the time being in force. Okay, so if they forfeit those articles, they can sell it. Protection of security of India, section 157A. Central government shall not disclose any information prejudicial to the interest of security of India. Okay, so if they say this information, if you disclose, this is harmful to the security of India, they will not disclose it. Central government can revoke patent which is prejudicial, means harmful to the interest of the security of India by issue of notification in official gazette. Okay, so now here you can get a question. The question could be that central government can revoke patent by following under section 64 by following the process. Okay, maybe something like that. So central government may not have to follow those processes. Okay, they can just issue notification is official gazette and the patent is revoked, simply revoked. Security of India means what? Fissile materials, traffic in arms, ammunition, war and military. These are the things are considered as security of India. So if they patent of fissile materials and they think that it is dangerous for the country, they can revoke the patent. Power of High Court to make rules. This is very simple and it becomes more relevant after this Tribunal Reform Act, where the appellate board has been abolished and the High Court comes in picture. So power of High Court to make rules. So we should understand that High Court can make rules for conduct and procedures in respect to all proceedings before it. So how things has to be done before the court, this only High Court can dictate, but High Court cannot dictate the patent rule. Okay. Power of central government to make rules, section 159. So in section 159, there is a huge list. Therefore, I have not compiled them all together. So you can see the huge list. So everything that is there, power of central government to make rules. Okay. So government can make rule for everything and anything that is in this section. So in the some substance, they can make rule for everything. So that is all they are written here. So you can read from 2, A, IA, IB, IC, ID, IE, 2, 3, 4, 5, 6, 7. But in that in a very simple format, we know that central government can make rule for this patent act and patent rules, everything they can make. So all those list is given out here. Okay. And section 160, rules to be placed before parliament. So once the rules are made, then they are placed before parliament. And every rule is laid before each house of parliament while it is session for a period of 30 days. Both houses should have a common decision. Then it is passed. And section 162. So this is not much important. So Repeal Act 2 of 1911 is so far as is related to patent and savings. So nothing much for us for exam purposes. Okay. And so that's all. So congratulations. So you have completed the entire sessions